Hello dear students, today we are going to study borrowing and lending under Indian company law. The main objectives of this lecture are to study the concept of borrowing by the companies, to evaluate and assess the power of company to borrow, to analyze and interpret the concept of charge created on company's assets, to study and analyze the intercorporate loans and investments made by the company. A suitable amount of capital is required in order to operate a company successfully. When internal capital sources such as issuing equity share capital or using accumulated profit are insufficient, an organization may turn to external capital sources such as bank loans, term loans, working capital loans, bank overdraft facilities, debentures, public fixed deposits, external commercial borrowings, etc. Therefore, borrowing is a method of arranging funds through outside sources with implied or explicit intention of paying it back. A company cannot borrow money unless it is so authorized by its memorandum. However, in case of trading company, it is not necessary that the object clause of its memorandum should expressly authorize it to borrow. Other companies must have a borrowing power clearly specified in the memorandum. Next, power of a company to borrow. The ability of the corporation to borrow is covered under section 179 of the Companies Act 2013. The directors of the company have the authority to borrow money, but they are only allowed to borrow up to the permitted amount. The power to borrow money can be delegated to a committee of directors, managing director, manager, or any other principal officer of the company by way of a resolution passed at a duly convened meeting of the directors. The resolution must, however, state the maximum sum that the delegatees may borrow. Often, the power of the company to borrow is unrestricted, but the authority of the directors acting as its agents is limited to a certain extent. For example, Section 180, Clause 1, Subclause C of the Act prohibits the board of directors of a company from borrowing a sum which, together with the money already borrowed, exceeds the aggregate of the paid up share capital of the company, its free reserves and securities, premium apart from temporary loans obtained from the company's bankers in the ordinary course of business, unless they have received the prior sanction of the company by a special resolution in general meeting. Explanation to Section 180, Clause 1, Subclause C provides that the expression temporary loans means loans repayable on demand or within 6 months from the date of the loan, such as short-term cash credit arrangements, the discounting of bills, and the issue of other short-term loans of a seasonal character, but does not include loans raised for the purpose of financial expenditure of a capital nature. It is further provided in proviso to Section 180, Clause 1, Subclause C that the acceptance by a banking company in the ordinary course of its business of deposits of money from the public repayable on demand or otherwise and withdrawable by check, draft, order or otherwise shall not be deemed to be borrowing of money by the banking company within the meaning of Clause C of subsection 1 of Section 180. The provisions of subsection 5 of Section 180 clearly laid down that debts incurred in the excess of the limit fixed by Section 180, Clause 1, Subclause C shall not be valid unless the lender proves that he lent his money in good faith and without knowledge of the limit imposed by subsection 1 being exceeded. The private companies have been exempted to comply with the entire provisions of Section 180 of the Companies Act 2013. Resultantly, special resolution is not required to exercise powers under Section 180 for private companies. Next, unauthorized borrowing. Where a company borrows without the authority conferred on it by the articles or beyond the amount set out in the articles, it is an unauthorized or ultra vires borrowing. Any act which is ultra vires the company is void. In such a case, the contract is void and the lender cannot sue the company for the return of the loan. The securities given by such ultra vires borrowing are also void and inoperative. Ultra vires borrowings cannot even be ratified by a resolution passed by the company in general meeting. Next, consequences of unauthorized borrowings. following are the consequences of unauthorized borrowings. No loan. In the first place, an ultra vires lender has no legal or equitable debt against the company. Consequently, he cannot sue the company to recover his loan. This was held in National Permanent Benefit Building Re ex P. Williamson case, followed by Madras High Court in Madras Native Permanent Fund Limited Re, where the court held that ultra vires loans are void and in truth have no existence. They do not create a relationship of creditor and debtor. In Sinclair versus Broham, it was held that ultra vires borrowings are forbidden on the grounds of public policy. To allow such borrowing to be recovered would be an evasion of that policy. Next, injection and recovery. Under the equitable doctrine of restitution, he can obtain an injection provided that he can trace and identify the money lent and any property which the company has bought with it. Even if the money advanced by the lender cannot be traced, the lender can claim repayment if it can be proved that the company has been benefited thereby. Next, subrogation. Where the money of an ultra vires lender has been used to pay off the lawful debts of the company, he would be subrogated to the position of the debtor paid off, and to that extent would have the right to recover his loan from the company. Subrogation is allowed for simple reason that when a lawful debt has been paid off with an ultra vires loan, the total indebtedness of the company remains the same. By subrogating the ultra vires lender, the courts are able to protect him from loss while the debt burden of the company is in no way increased. But the subrogated creditor will not enjoy the priority of the original creditor. The best illustration to explain the point is Wrexham Mould and Connaught Quay Railway Company Limited Re, wherein a company had borrowed to the full extent of its powers by issuing three different series of debentures, A, B and C. A had priority over B and B over C. The company took a fresh ultra vires loan from the plaintiff to pay interest on A debentures. It was held to the extent to which the plaintiff's money was used to pay off legal debts. He became a legal creditor, but he was not entitled to the priority of A debentures. Next, identification and tracing. As long as the money of the lender is in the hands of the company in its original form, or its products are still capable of identification, he may claim that money or its products. But the problem is much more difficult when the lender's money and that of the company have become mixed up. There is only one common fund composed of the lender's money and company's money, but no part of it is traceable as belonging to one or the other. In such a case, the lender may perhaps be helpless, but in the winding up of the company, he may claim pari passu distribution of the assets with the shareholders. This was also held in Sinclair versus Broham. Next, regular borrowings. If the borrowing is within the powers of the company, the lender would not be prejudiced simply because its officers have not applied the loan to unauthorized activities, provided that the lender had no knowledge of the intended misuse. For instance, in VKRST firm versus Oriental Investment Trust Limited, under the authority of a company, its managing director borrowed large sums of money and misappropriated them. The company was nevertheless held liable. The Companies Act in section 180 clause 1 subclause C provides that directors should not borrow beyond the paid up capital of the company and its free reserves. Subsection 5 further declares that such a loan shall not be valid unless the lender proves that he advanced the money in good faith and without knowledge that the limit has been exceeded. Where the loan has not been taken in the name of the company, it will not be liable even though it may have benefited. An illustration in point is Suraj Bahu versus Jetli and Company. P and Company were the managing agents of L and Company, which was in liquidation. P was the manager. P borrowed a sum of money from J in his own name. In one letter to J, he indicated that the loan was for a requirement of L and Company and that company had actually benefited. But it was held that there was no intention to bind L and Company. The mere fact that the company had benefited was not in itself sufficient to bind the company. A distinction should always be made between a company's borrowing powers and the authority of the directors to borrow. Where the directors borrowed money beyond their authority, but the borrowing is not ultra vires of the company, such borrowing is called intra vires borrowing, but outside the scope of agent's authority. The company will be liable to such borrowing if the borrowing is within the director's ostensible authority and the lender acted in good faith, or if the transaction was ratified by the company. Where the borrowing is intra vires of the company but outside the authority of the directors. For example, where the articles provide that the directors shall have the power only up to rupees 100 lakhs and prior approval of the shareholders would be required to borrow beyond rupees 100 lakhs. Any borrowing beyond rupees 100 lakhs without shareholders approval is intra vires borrowing by the company but outside the authority of the directors and can be ratified by the company and hence becomes binding on the company. The company would be liable particularly if the money has been used for the benefit of the company. Here the legal position is quite clear. The company has power or capacity to borrow, but the authority of the directors is restricted either by the articles of the company or by the statute, and they have exceeded it. The company may, if it wishes, ratify the Agents Act, in which case the loan binds the company and the lender as if it had been made with company's authority in the first place. On the other hand, the company may refuse to ratify the Agents Act. Here, the normal principles of agency will apply. The doctrine of indoor management, also known as rule in Royal British Bank versus Turkand, shall protect the lender provided he can establish that he advanced the money in good faith. A third party who deals with an agent knowing that the agent is exceeding his authority has no right of action against the principal. Bearing in mind that the memorandum and articles are public documents, the contents of which the third party is deemed to know, he will obviously have no right of action against the company if the agent's lack of authority is obvious from reading them. But a third party is not affected by secret restrictions on the agent's authority, as the lack of authority is not clear from the public documents and the lender cannot be aware of it from some other source. Therefore, the company will be liable. Dear students, let us look at some of the judicial pronouncements relating to borrowing power of a company. Executors versus Humphreys. In this case, it was held that if the borrowing by the directors is ultra vires their powers, the directors may, in certain circumstances, be personally liable for damages to the lender on the ground of implied warranty given by them that they had power to borrow. Next, Deonarayan Prasad Badhani versus Bank of Baroda. Sometimes it happens that a power to borrow exists but is restricted to a stated amount. In such a case, if by a single transaction an amount in excess is borrowed, only the excess would be ultra vires and not the whole transaction. Next, Sri Balsar Aswati Limited versus Parmeshwara Iyer. The acquiescence of all shareholders in excess loans contracted by directors beyond their powers but not ultra vires the powers of the company would be sufficient to validate such excess debts. In Lakshmi Ratan Cotton Mills Company Limited versus JK Jute Mills Company Limited, if the borrowing is unauthorized, the company will be liable to repay. if it is shown that the money had gone into the company's coffers. In Equity Insurance Company Limited versus Dinshaw and Company, it was held that where the managing agent of company who is not authorized to borrow has borrowed money which is not necessary, neither bona fide nor for the benefit of the company is not liable for the amount borrowed. Next, types of borrowings. A company uses various kinds of borrowing to finance its operations. The various types of borrowings can be generally categorized into long-term borrowing, short-term borrowing, secured borrowing, unsecured borrowing, syndicated borrowing, bilateral borrowing, private borrowing, public borrowing. First, long-term borrowing. Funds borrowed for a period ranging for 5 years or more are termed as long-term borrowings. A long-term borrowing is made for getting a new project financed or for making big capital investment like purchase of property, plant, equipment and other fixed assets. Generally, long-term borrowing is made against charge on fixed assets of the company. Second, short-term borrowing. Funds needed to be borrowed for a short period, say for a period up to 1 year or so, are termed as short-term borrowings. This is made to meet the working capital need of the company. Short-term borrowing is generally made on hypothecation of stock and debtors. Third, medium-term borrowing, where the funds to be borrowed are for a period ranging from 1 to 5 years. Such borrowings are termed as medium-term borrowings. Fourth, secured borrowings. A debt obligation is considered secured if creditors have recourse to the assets of the company on a proprietary basis or otherwise ahead of general claims against the company. Fifth, unsecured borrowings. It comprises of financial obligations where creditors do not have recourse to the assets of the company to satisfy their claims. Sixth, syndicated borrowing. It is when a borrower requires a large or sophisticated borrowing facility. This is commonly provided by a group of lenders known as syndicate under a syndicated loan agreement. The borrower uses one agreement covering the whole group of banks and different types of facility rather than entering into a series of separate loans, each with different terms and conditions. Seventh, bilateral borrowing. It refers to a borrowing made by a company from a particular bank, financial institution. In this type of borrowing, there is a single contract between the company and the lender. Eighth, private borrowing. It comprises of bank loan type obligations whereby the company takes the loan from a bank financial institution. Ninth, public borrowing. It is general definition covering all financial instruments that are freely tradable on a public exchange or over the counter with few, if any, restrictions, that is debentures, bonds, etc. Next, charge. The power to borrow includes the power to mortgage the company's assets or to create a charge upon them. Section 2, Clause 16 of the Companies Act defines charge as an interest or lien created on the property or assets of the company or any of its undertaking or both security and includes mortgage when existing as well as future property of the company is agreed to be made available as a security for the repayment of the debt. This is called a charge on the property of the company. The charges that may be created on its assets by a company are of two types: fixed charge and floating charge. Fixed charge. A fixed charge, which is also known as specific charge, is always created in some definite and ascertained property of the company. The best examples of fixed charge may be a charge on the land and building of the company, plant and machinery of the company, though the property remains in the possession of the company, but it prevents the company from dealing in that property without the consent of the holder of the charge. Second, floating charge. A floating charge is a charge which is not specific charge. A floating charge is an equitable charge which is created on some asset which is constantly changing. It is not attached to any specific property of the company, but it covers any fluctuating asset of the company. The best example of a floating charge could be a charge on the stock in trade and book debts of the company. Contrary to the fixed charge, the company can deal in such assets in its normal course of business until the charge becomes fixed on the happening of certain event. Next, registration of charges, section 77 of the Companies Act. It is the duty of every company creating a charge to register the particulars of the charge with the registrar of companies. The instrument of the charge has to be signed by the company and charge holder. The instrument of charge has to be in the prescribed form and has to be filed with the prescribed fee and within 30 days of its creation. The registrar can permit for registration within the extended period of 300 days on payment of prescribed additional fee. The registrar has to issue a certificate of registration in the prescribed form and manner both to the company and charge holder. Without such certificate, the charge is not taken into account by the liquidators or any creditors. Next, consequences or effects of non-registration of a charge. Where a charge required to be registered with the registrar is not registered, the following consequences may arise. First, the charge becomes void. The charge becomes void as against the liquidator, where the company goes into liquidation, and against the creditors. Second, the money secured by the charge becomes immediately payable. When a charge becomes void against the liquidator or the creditor, the money secured thereby shall become immediately payable. Third, no lien on the title deeds. The holder of the charge whose charge has become void for non-registration shall have no lien on the title deeds or documents deposited with him. Fourth, to be treated as unsecured creditors. At the time of liquidation of the company, the creditor having an unregistered charge shall become an unsecured creditor of the company as the charge has become void against the liquidator and the creditor. Fifth, penalty. If default is made in filing with the registrar for registration, the particulars of any charge created by the company which should have been registered, the company and every officer of the company shall be punishable with fine which may be extended to rupees 10,000 and further a fine of rupees 5,000 for every day during which the default continues. Next, intercorporate loans and investments. Section 186 of the Companies Act 2013 talks about the loans and investments made by the company. Investing in other companies is one of the best ways to expand the company internationally and in India as well. Buying or acquiring a company helps people to start their operations instantly, as well as enables one to gain foreign expertise. Companies invest in other companies for the following reasons. Hedging. Companies can invest in other companies to eliminate or reduce the risk of their businesses. For instance, a company of steel production can invest in iron extraction to eliminate the raw material price soaring. Liquidity management. A company generates money and wants to hold it for tax payment or until a chance is available to introduce a new product. So they can either hold it in banks or decide to buy shares for better returns and less inflation impact. Partnership on the long term. A company can be looking for mergers and acquisitions with other successful companies. In this way, they can gain control in the long run to form a new successful union. Eliminate competition. A company may want to eliminate its competition by getting control of other companies. For instance, one company may buy shares of other company in order to eliminate competition in the same sector. Speculation. A company has professional advisors and experts who think the other company's price is undervalued, so it decides to invest in that company to generate extra returns. Next, intercorporate loans and investments. Section 186 of the Companies Act 2013 provides for loans and investments by company, which corresponds with Section 372A of the Companies Act 1956. A company is entitled to provide another company with loans, investment, securities, and guarantees. The same can be done either with the consent of the board or that of the shareholders. Next, Register of Investments Loans. Section 186, Clause 9 of the Act provides that the company has to keep and maintain a register, including particulars about investments, loans, securities, and guarantees as per the prescribed manner. The register should be maintained in the manner prescribed. The particulars are as follows: the name of the company, the date on which the loan or investment is made, the date on which security or guarantee has been provided against the loan or investment, the amount, purpose, and terms of the loans, investments, securities, and guarantees. The particulars should be entered in the register in chronological order within 7 days of the making of the loans or investments. Section 186, Clause 10 of the Act provides that the register should be kept at the registered office of the company. The same should be open to inspection to members of such offices. They can also take extracts and demand copies of the same on the payment of a prescribed fee. Next, exceptions. Section 186 does not apply to certain transactions. This section would not be applicable to any loans or guarantees given by a banking company, an insurance company, or a housing finance company for transactions made in the ordinary course of business. A company framed with the sole purpose of financing industrial enterprises or for providing infrastructural facilities. An organization that purchases the right of shares. A company whose primary business is the acquisition of shares. A registered non-banking finance company that primarily focuses on the acquisition of securities. A government company that operates defense production. Next, penalty provisions. There are majorly two types of default and are treated differently. One is the violation of the main provisions, and the second is default in maintaining the register. A very light penalty is provided in the matter of the register. If a company contravenes or violates the provisions of the given section, the company shall be punished with fine of a minimum of 25,000 rupees, which can be extended to 5 lakh rupees. The officers of the company who are in default will also be punished with imprisonment for a term of maximum 2 years, along with a minimum fine of 20,000 rupees, which can be extended to 1 lakh rupees. Next, investment in one's own name. Section 187 of the Companies Act 2013 deals with investment of company to be held in its own name. This section requires all the investments made by a company on its own behalf to be held by the company in its own name. Where a company advances money by way of a loan to another company in order to enable the borrowing company to make investments in its shares, that does not amount to investment in its shares by the lending company in another company's name. If the company's director or nominee becomes a director in another company and is required to hold qualification shares, then they may be held jointly in the name of the company and such director. There are certain exceptions to this provision. The section does not apply to the investments that are made by such a company whose primary business is to buy and sell securities or shares. A company can hold shares in the name of one or more nominees in its subsidiary company if the number of members is going below the statutory minimum. A company can deposit its shares or securities with bankers for the collection of dividends or facilitate their transfer. In case the transfer is not effected within the period of 6 months, they should be held by the company in its own name. A company can transfer its shares or securities for the performance of an obligation or as security for a loan to another person. A company can hold investments in the name of a depository. This can be done when the investments are in the form of securities held by the company as a beneficial owner. In order to enable their identification, such exceptional transactions have to be entered in a register. If a company contravenes or violates a provision of this section, the company should be punished with a minimum fine of 25,000 rupees, which can be extended to 25 lakh rupees. The defaulting officer of the company can be punished with imprisonment for a term of a maximum of 6 months or a minimum fine of 25,000 rupees, which can extend to 1 lakh rupees or both. With this, we end today's lecture. Hope you enjoyed it. Thank you.